Hey guys, it's Gary. Got a really cool email the other day from a friend agent up in Greenville. Had a question. I think I've probably done a video about this many years ago, so I thought I'd just do another one. It's about whether minors should own property or not. And what the person was trying to do, what his client was trying to do, is I think buy property, put his minor child's name on the property so they can just avoid the probate process if something ever happened to them. The problem with putting a minor, there's nothing illegal about a minor owning property, but the problem is when they try to dispose of the property. So if you're under the age of 18 and you want to sell the piece of property, your parents want to sell it, whatnot, you have to have a guardian and a conservator appointed by the court. That doesn't mean that the parents get to sign for you, and if you're under the age of 18, you can't sign. So you're going to have a guardian ad litem and a conservator, which are two different people, which are usually two different lawyers, and typically you're going to have a lawyer to file the paperwork. So you're looking at 2 to 3 lawyers to get that done. That's very expensive because of that, and it's also time consuming because the conservator or the guardian have to meet with the child, meet with the parents, figure out what the status is, why they're doing it, and so forth. Plus all the money that's realized from that sale also has to go back to the minor or to another house for the minor. So you really, really don't want to ever put a child on title. Now, I understand if the child's maybe 17 years and 9 months and you're buying a house for them to go to Clemson or Carolina, I understand that. 3 months are going to be of the age 18, okay. Still risky because understand also any judgments that attach against your child also attach against the property. So if your 18-year-old college child decides to go out and get a couple credit cards and not tell you about it, and those credit cards go to a judgment against them, which they easily do, now all of a sudden those attach to the property as well and you can't sell it. Secondly, let's say that child starts dating somebody that doesn't like you and you don't like them, and they're in your child's ear saying don't agree to sell anything. So even if they're over the age of 18, you can't sell the property without your child signing the deed. And if your child is involved with somebody that doesn't like you, you don't like them, they may be influencing your child not to sign that deed as a way to get to you. So there's a lot of factors involved. So my advice is never, ever put somebody under the age of 18 on title. If they're over the age of 18, you got to make sure that that child has good credit. It's not going to do things to get bad credit and so forth. So I hope that gives you a good idea of what to look for when you're working with a minor and putting minor on children on title. If they're looking to try to avoid the state issue, the best thing they ever could do is just pick up the phone and call Blair Cato and ask to speak to Marshall Minton. She is our estate planning attorney. She has young kids as well, and she can help draft a very simple will that can take care of those issues of property being transferred. So I highly recommend just using her services for that. So I hope everybody has a wonderful weekend, and we will see y'all next week. Merry Christmas.